Number one, this lady was astute enough, and her attorney that drafted her last will had also drafted her previous will. And that's one way to increase the chances of successfully defending against a will contest if you have multiple wills that are consistent with the naming of beneficiaries, so that the party who's challenging the will, like this family member you mentioned, has to knock out multiple wills, succeed in their will contest. So that's one point. The other point I take from this case is it's critical to at least have one will. In the absence of a will, family member who challenged this lady's wills would have inherited automatically under the state intestacy law. When you die without a will, the closest next of kin will automatically receive assets as a beneficiary of your estate. But if you take the time and go to an experienced estate planning attorney and to draft your will, you have a much better chance of accomplishing your estate planning goals.
Absolutely, and we do take into consideration every family situation is unique. There are some times where you have a family member that you don't see or speak to for years and you have no relationship with, and maybe you want to make a charitable donation instead.
Right.
It's up to you what you want, and we will do our best to make sure that your wishes are taken into consideration.
Yes, in those cases, we typically advise the client to have us put a clause in there that said I specifically exclude the following individuals, and that way it eliminates the argument that my aunt temporarily forgot about me when I did the will. This way it's clear in the will that they're excluded.
So if you have a situation like this, or you would like to speak to us a little bit more about your estate planning and preparing a last will and testament that meets your needs and your desires, then absolutely please give us a call.